Good evening and a heartfelt welcome to the Nuremberg Academy Lecture 2025 in Courtroom 600 of the Nuremberg Palace of Justice. My name is Christoph Safferling and I'm the director of the International Nuremberg Principles Academy and your host for tonight. So we assembled here for a lecture on crimes against humanity. This lecture connects well with the previous Nuremberg Academy lectures that we had. In 2023 on the crime of aggression by Professor Klaus Kress. On the crime of genocide by Professor William Schabas, 2024. The topic crimes against humanity has a lot to do with this courtroom in which we find ourselves in tonight. Other than the crime of genocide, crimes against humanity were actually prosecuted in this courtroom. Indeed, the IMT Charter of 1945 established crimes against humanity as a new concept, a concept that was necessary in order to address the horrific atrocities that had been committed by Nazi Germany. The existing concept of war crimes in international law was felt to fall short of covering the Holocaust and the industrialized killing of millions of Jews and others. In the end of the 22 accused in Nuremberg, 16 were convicted for crimes against humanity. Baldur von Schirach and Julius Streicher were even convicted only for crimes against humanity. However, the International Military Tribunal was cautious with applying this rather new concept. Even if the rationale of crimes against humanity was quite plausible and easy to grasp, the concept being an amalgamation of the core substances of criminal law to be encountered in the criminal codes of all civilized nations. As Christian Tubuschat once phrased, it was unclear whether the concept would apply only in times of war or also in times of peace. Also, Justice Jackson, the chief prosecutor of the USA in Nuremberg, favored a narrow approach. In astonishing bluntness, he stated during the London conference in preparing the IMT Charter, and I quote, "We have some regrettable circumstances at times in our own country in which minorities are unfairly treated." End of quote. I see my American colleagues nodding. So the aim was to avoid interference of international law into interior sovereignty of a state. The uncertainties about the concept of crimes against humanity go even so far that in the German language there is always a dispute about the translation, because the term in German, Verbrechen gegen die Menschlichkeit, can mean two things: crime against mankind or against humanness. So it's either a crime against the human race as such, or it's merely a lack of empathy. So, which is the underlying rationale of that crime? Questions to which we will expect answers tonight when our guest of honor, Professor Leila Sadat, speaks about the necessity to adopt a convention on crimes against humanity and why the IMT trial and the Nuremberg principles do not suffice. I'm very honored to welcome to the Nuremberg Academy Lecture 2025 such an esteemed audience. Let me welcome first of all State Minister Katja Keul from the German Foreign Office. Ms. Keul has already been at the Nuremberg Academy Lecture 2 years ago, so I welcome a regular visitor to this event. Dr. Thomas Dickert, President of the Upper Regional Court and landlord of this Palace of Justice, and Dr. Nasser Ahmed, representative of the City Council of Nuremberg. All three will enrich this evening by their welcome remarks. I welcome representatives of the Diplomatic Corps, James O'Shea, Consul General of the Republic of Ireland, Annelies Faro, Consul General of the Kingdom of the Netherlands, and Maximilian Kallenbach, representative of the Consul General of Switzerland. I welcome also Tobias Winkler, member of the Federal German Parliament in Berlin. There are also representatives of several ministries. Christoph Henrichs of the Federal Ministry of Justice, Johannes Eberle, I don't see him here, Stefan Schumann of the Bavarian Ministry of Justice, and many representatives and colleagues from the Bavarian judiciary, like the Vice President of the Regional Court Nuremberg-Fürth, Dr. Helmut Köhler, and the President of the Nuremberg Bar Association, Dr. Uwe Wirsching. A hearty, warm welcome. Ladies and gentlemen, I also welcome the members of the advisory board, the President, Silvia Fernandez, warm welcome, and also our new members, Judge Rytzikova and Judge Piotr Hofmansky. Great to have you. And I also welcome Dr. Rainer Huhle from the Human Rights Center in Nuremberg, Dr. Dorothea Weidbrecht from the Elisabeth Käsemann Foundation, and of course Joachim Hamburger, the President of the Nuremberg Jewish Community. Moreover, a hearty welcome to all of you, colleagues and friends of the International Nuremberg Principles Academy. So now I'm very glad to give the floor to State Minister Katja Keul from Berlin for her welcome remarks. Thank you.
Thank you, dear Professor Safferling, dear Professor Sadat, Excellencies, distinguished guests, ladies and gentlemen. It is a great pleasure to speak to you at this lecture of the International Nuremberg Principles Academy. And thank you, Professor Safferling, for organizing this event and for inviting me. I feel honored to address such a distinguished group of experts in international criminal law today. And I believe the venue and the time could not be more appropriate. 80 years ago, this courtroom served as the cradle of international criminal law when the victorious Allies resolved to hold Nazi perpetrators accountable for their crimes. They did so by upholding due process and applying principles that became soon after known as the Nuremberg Principles. Here, in this very courtroom, a process was launched that ultimately led to the foundation of the International Criminal Court some 50 years later. It was one of the last post-war institutions to take shape. 1998 was the moment in history when there was broad consensus that the world needs a judicial body that holds perpetrators accountable for war crimes, genocide, or crimes against humanity. The ICC is the product of the remarkable development of international law in the last 80 years, starting in Nuremberg, but also very much influenced by the end of the Cold War era. One may claim that its foundation marks the high point of building international rule of law. Today, a quarter century later, this world order, and with it the ICC, is under extreme pressure. Russia, as a permanent member of the Security Council, should bear a special responsibility for world peace and international security. And yet, Russia is engaged in a war of aggression to change international borders. The threat of the annexation of territory by major powers, even the new US president, is a very bitter reality. As the ICC addresses the major political crisis of today, it faces cyber attacks, arrest warrants against judges, and newly enacted US sanctions, the ultimate extent of which we do not know yet. Legal order is threatened by violation of its rules or pressure on its officers. The law of the strongest seems to be gaining the upper hand over international law. The resilience of a legal system depends on how the system itself reacts to these violations. For the international legal order, this depends on how state parties and international organizations such as the United Nations, react to threats and violations. It also depends on the position taken by international legal scholars as well as on public opinion. Do actors turn away from the international legal system, discard it as irrelevant and useless? Or do they stick to using the legal system for solving their disputes? Do they uphold the claim of validity of international law? And do they continue to develop the system despite the pressure? With regard to the ICC, states have taken a stance already. At the beginning of February, 79 state parties of the Rome Statutes, including Germany, signed a joint statement in support of the court. Beyond that, state parties have engaged and continue to engage decision makers on the US side to reconsider sanctions. Many state parties, Germany included, have paid our annual contributions in early and in full, so as to give the court additional financial stability in uncertain times. However, the signature of only 79 state parties out of 125 leaves much to be desired. It goes to show that more support is needed by state parties. And it is not enough to defend the status quo. Instead, we need to strengthen international law by further developing it. One opportunity to do so is the forthcoming review of the Kampala Amendments on the crime of aggression. The special session of the Assembly of State Parties in July will provide an opportunity to strengthen the ICC. It will also provide an occasion for public debate on the need for international criminal jurisdiction, and hence an opportunity for states parties and societies to once more rally behind the court. Germany contributes to that process by organizing 3 regional conferences in Brasilia, Seoul, and Addis Ababa. Another area of our common effort is our work on a convention on crimes against humanity. No such global convention currently exists, unlike with respect to genocide and war crimes. Last November, in a historic decision, the UN General Assembly has agreed on the negotiation mandate for a conference of states to draft such a convention. This is an opportunity to reach a new milestone in the common fight against impunity. Such a convention could facilitate the harmonization of national laws and such streamline global efforts to fight for accountability, an endeavor more pressing than ever. It would also encourage the horizontal cooperation between state parties. Germany has contributed to the process so far, in particular through 2 workshops that we organized in New York in springs of 2023 and 24. This enabled us to promote a broad-based dialogue with all regional groups, especially countries of the Global South and civil society. Ladies and gentlemen, right now we are confronted with threats to world order unknown since the Second World War. States, even members of the UN Security Council, are willingly violating international law or questioning its validity. There can only be one answer to these threatening developments. We must deepen global partnerships to face these challenges, and we must work together more closely than we have ever done before. This is a question that concerns the entire international community. If we lose the consensus that was found after 2 world wars and 60 million deaths, the consensus to solve conflicts by law and not by weapon, it will be hard to come back to it. Rule of law depends on the political will to impose it. That's why it will be at the core of German foreign policy to defend and protect this valuable consensus wherever it is called into question. The near future will be extremely hard on international courts and legal systems. But there is a chance we can face this challenge if we stand together firmly with our partners around the world. Germany invites all states, scholars, and practitioners of international law to join this effort. And I'm now looking forward to Professor Sadat's Academy Lecture on the history and development of crimes against humanity. And I would be delightful if we could meet up afterwards at the reception for further discussion and exchange. Thank you.
Thank you, State Minister Keul, for this welcome remark on the firm commitment of the federal government towards the Nuremberg principles. Now, the second welcome remark, Dr. Thomas Dickert, the President of the Upper Regional Court.
Ladies and gentlemen, Excellencies, as the landlord of the Nuremberg Palace of Justice, I would like to welcome you to this year's Academy Lecture of the International Nuremberg Principles Academy in this famous Courtroom 600 and also online. On September the 11th in 1916, in the middle of the First World War, the Bavarian King Ludwig III inaugurated this court building in a festive ceremony. On the occasion of the inauguration, the king said he wishes and had no doubt that justice would always be done in this building, regardless of the person. The king was fully aware that he himself, the Bavarian government, and the Bavarian parliament were not allowed to influence the workings and decisions of the court. In 1862, the jurisdiction was separated from the administration in Bavaria. This organizational act was intended to implement the idea of the separation of powers in the Kingdom of Bavaria. The principle of separation of powers is a fundamental principle of the constitution of every democratic constitutional state. In his 1748 essay on the spirit of the laws, Montesquieu divided the powers of the state into the legislative, executive, and judicial branches. The separation of powers was first proclaimed as a political program in the Constitution of the United States of America in 1788, where it was referred to as checks and balances. As president of a higher regional court, I am particularly interested in the condition and position of the third power in the structure of the state. In a democratic constitutional state, judges are personally and objectively independent. They are not servants of power, but servants of the law. They ensure compliance with the legal system, legal peace, fair trials, and the enforcement of human rights against the politics of force. I'm very concerned that the independence of the judiciary is increasingly coming under pressure from the influence of governments. The decisions of independent courts are often seen as obstacles by the populists and autocrats of this world. This is because they want to implement their political program as quickly as possible and do not want to be held back by laws and by international treaties. For example, in Italy, an important political project of Italian Prime Minister Meloni is to reduce the number of migrants. She has therefore reached an agreement with Albania, where a reception center and a deportation camp for refugees have been set up with Italian taxpayers' money. If the migrants have no prospects of staying in Italy, the political idea is that they should not enter Italy, but be taken directly to Albania. Italian courts have blocked previous attempts to use the camps in Albania. They decided that all migrants who were to be detained to Albania had to be brought to Italy. The Italian government has therefore launched a campaign against the judiciary. It claims that judges are politically motivated and not neutral, and is calling for a separation of state powers to be redefined. The Italian Association of Judges is very worried about this development. It is demanding that the independence of the judiciary is respected. Judges do not have the task of cooperating with the government. Their decisions should not depend on which political wind is blowing. Another example, the USA. President Trump signed an impressive number of decrees on his first day in office. Their implementation was partially stopped by provisional court rulings to prevent irreversible facts from being established. Among other things, the constitutional principle of the right to citizenship by birth, which was already standardized in the 14th Amendment to the Constitution in 1868 and has been applied constantly ever since, is intended to be abolished. The rulings of the courts led to serious attacks by the US government on the independent judiciary. I quote, "Highly political judges want to slow us down or stop us," complained President Trump on social media. "Judges must not control the legitimate power of the executive branch," wrote Vice President Vance. Elon Musk even suggested that the worst 1% of appointed judges should be dismissed every year. This is supposed to sort out the most corrupt and least competent judges. When the competent judge in Washington recently stopped the deportation of Venezuelan criminals to El Salvador due to the lack of a legal basis for that, the reaction became even more aggressive. I quote, "We have out-of-control judges who are destroying our country. We have very bad judges, and these are judges that should be not allowed." These statements are directed against the independence of the judiciary and the principle of the separation of powers. Judges are declared to be enemies of the state or the people. The will of the people is being played off against the law. It is essential for the rule of law that the third estate does not submit to the power of the government. In a constitutional state, it is crucial that the law does not give way to power. The law cannot be swept away with a slap on the fist of the cabinet table. In a constitutional state, the law must be the subject of parliamentary procedures and negotiation processes at an international level. Judges cannot be removed because their work is not liked. John Roberts, Chief Justice of the USA, has therefore felt the need to make the following brief and concise statement. I quote, "For more than 2 centuries, it has been clear that impeachment of judges is not an appropriate response to a disagreement over a judicial decision. That's what appeals are for." On February the 6th in 2025, President Trump signed a decree on sanctions against the members of the International Criminal Court who are involved in investigations against US citizens or US allies. Trump accused the court of unlawful and unfounded actions against the USA and its close ally Israel. The president of the International Criminal Court, Tomoko Akane, sees this action as an existential threat to the International Criminal Court. This is where the International Nuremberg Principles Academy steps in. It will be its task to observe how the International Criminal Court is put under pressure and what reactions are possible from the member states of the Rome Statute. These developments make the International Nuremberg Principles Academy more important than ever as a forum for the exchange and further development of international criminal law. It has once again proven to be a fortunate coincidence that the Federal Republic of Germany, the state of Bavaria, and the city of Nuremberg have jointly established the International Nuremberg Principles Academy. I wish you all a productive evening in the Academy Lecture and an inspiring stay in Nuremberg and in this wonderful Courtroom 600. Thank you very much.
Yeah, thank you so much, dear Thomas, for reminding us of the contestations of the rule of law and in particular also the responsibility of this academy. It's well noted. So for our final welcome remark this evening, Dr. Nasser Ahmed, the Nuremberg City Council representing the city of Nuremberg. Asa, please.
Dear ladies and gentlemen, dear Professor Safferling, dear Professor Sadat, I'm very, very honored to meet you here in my hometown, my home city, Nuremberg, and I want to welcome all of you to this historic city of Nuremberg. It is my great honor as city councillor of this remarkable city to welcome you today to this distinguished lecture of yours, held in this storied hall, as the both speakers before me told or said already, in this hall 600 of the Justizpalast. I stand in today for our Lord Mayor, Mr. Markus König, and on his behalf and in behalf of the city and in the spirit of the International Nuremberg Principles Academy, I extend my warmest greetings to all of you gathered here and online. Nuremberg stands as a city with a profound and reflective history, a city that has transformed its past into a commitment to peace, justice, and the protection of human rights. Once known as Hitler's favorite city, today Nuremberg has reinvented itself as a vibrant, a multicultural city where 51% of our residents have a migration background. We are the majority. This transformation is a testament to our collective will and the enduring strength that lies in our diversity and solidarity. I speak from personal experience when I say that our city is truly a city of opportunities. My own journey is a living example of this transformation because my parents arrived here as refugees, and I was fortunate to be given a chance to serve. I became Nuremberg's first black city councillor, a milestone beyond many milestones that reflects the historic reinvention of our city after the horrors of the 20th century. Our shared history here in Nuremberg of overcoming the past has inspired us to build a future where every individual can thrive. Yet, despite our rich diversity and the vibrant spirit that characterizes our city, we must acknowledge the challenges we face today. Right-wing extremism, also in our city, continues to threaten the very fabric of our community by attempting to sow division and discord. However, the overwhelming majority of our citizens remain deeply committed to the values of tolerance, democracy, and mutual respect. Together with countless dedicated community members, we stand resolutely against extremist forces, and we work tirelessly to reinforce the institutions of democracy and to ensure that every voice advocating for justice and inclusivity is heard. Nuremberg not only commemorates its history, but also actively shapes its future. with institutions as the INP, for example, with the Way of Human Rights, with the International Nuremberg Human Rights Prize, not to forget. And we as City Council and our forefathers in this City Council, we made a resolute decision. Only symbols of peace and intercultural understandings shall grace our decisions in City Council and the signs in streets and public spaces. This decision, taken in the 1980s and 90s, embodies our commitment to promoting a society where the lessons of the past, which you talked about, should guide us toward a future built on mutual respect in our city and to be a beacon for other cities to follow and other countries to stay on this side of history. And in this unique setting, where the echoes of history remind us of the imperative for accountability, we see a resilient community determined to build a future based on universal human rights. The Nuremberg Principles, born from the need to confront crimes against humanity, have not only reshaped international law, as you said, Ms. State Minister, but also serves as a moral compass for nations seeking to uphold justice and human dignity. And it's more difficult than ever to uphold it. And so we are proud as City Council in hosting this lecture, as hosting many, many events as this one in the last years and hopefully in the future. The International Academy Nuremberg Principles is a forum that fosters the critical exchange of ideas and deepens our collective understanding of the challenges and opportunities inherent in our global commitment. And as we engage in discussions, as today, and bridge the past and the future, we also acknowledge the ongoing struggles for justice around the world, and it is our shared duty to ensure that the lessons of history guide us towards a more and just peaceful world. Before I conclude, I invite you all to explore not only the rich cultural and the historical tapestry of Nuremberg, but also our culinary heritage. Do not miss the opportunity to savor one of our local specialties as well. Thank you for being here. Thank you for this chance for our city of hope and for contributing to this important dialogue. I wish you all an inspiring and productive session. I'm very interested in what you have to say in our city of human rights. And I wish you all not only a constructive dialogue and interesting ideas, but also afterwards together a pint of Franconian beer and 6 Franconian sausages. Thank you very much.
Dear Nasser, thank you so much for your welcome remarks. It's always a pleasure to feel also the support that the City of Nuremberg and the City Council in particular has for this academy. Now, let me introduce to you our speaker, Professor Leila Sadat. I noticed that she became a bit nervous whether there would be still time for her to speak tonight. There is, Leila. Professor Sadat has already been in Nuremberg. I'm sure she already tasted sausages and beer, and has already spoken in this room at conferences. She is the James Carr Professor of International Criminal Law at the Washington University School of Law in St. Louis, and she has been the director of the Whitney R. Harris World Law Institute at that university, which of course goes back to Whitney Harris, a former prosecutor in the Nuremberg trial, who prosecuted in this very room. Leila holds degrees from Tulane University Law School, Columbia Law School, and l'Université de Paris à Sorbonne. Today, Professor Sadat is one of the leading experts in international criminal law worldwide. She has published widely on several aspects, never shy to criticize politics, both at the UN and even of her home country, the United States. She's the president of the International Law Association, the American branch, vice president of the Association Internationale de Droit Pénal. She was a delegate at the 1998 Rome Conference, at the 2010 Review Conference in Kampala. She has been a special advisor to the prosecutor of the ICC, and I could go on forever and ever, and then there would indeed be no time for her to speak tonight. She is not only a friend of the Academy, I'm glad to say that since very recently, she is also a member of the Advisory Council of the Academy, and I'm very pleased that you accepted our invitation. Above all, she has been invited to speak tonight because she is very much the person behind the initiative for a Convention on Crimes Against Humanity. What Cherif Embassyouny, one of the protagonists of international criminal law, even in the 70s and 80s of the last century, has long called for, Leila Sadat now brings this to a completion, an international convention on the prevention and punishment of crimes against humanity. The United Nations have taken up this proposal, and they are preparing the road for a conference of plenipotentiaries to adopt such a convention in 2028-29. So Leila Sadat might well become, for the crimes against humanity, what Raphael Lemkin is for the Convention on the Prevention and Punishment of Genocide. But of course, Leila is much more adorable compared to the somewhat stubborn Lemkin. I'm very pleased and honored that you have accepted our invitation, and I'm giving you the floor to deliver the Nuremberg Academy Lecture 2024, The Long Arc of Justice, Forging a Convention for Crimes Against Humanity. Ladies and gentlemen, please welcome Professor Leila Sadat.
Thank you so much, and it's just such an honor to be here today. Good afternoon. Can you hear okay? Oh, yes. I haven't gotten taller since the last time I spoke here. I'm really honored to return to Courtroom 600 to talk about crimes against humanity in this really storied venue where it first emerged as positive law. Thank you to Dr. Christoph Safferling for the kind invitation, to the staff of the Academy here in the room and elsewhere for making this visit possible. And it's really good to see so many familiar faces and friends in the room. I would like to dedicate this lecture to three mentors, friends, and extraordinary individuals who are no longer with us, but have served as an inspiration to me over the many years. Cherif Embassyouny, the late Ben Ferenz, and the late Whitney Harris. I can actually feel their presence here in this room with us today. I'm also equally honored and inspired by the introduction by Minister of State Katja Keul, Dr. Thomas Dickert, and also Dr. Nasser Ahmed. Your presence here is a sign of your commitment to the work of the Academy and really a tribute to the importance of the subject today. I'd be remiss not to thank the Nuremberg Academy itself, because the Academy has supported this activity, as has the German government. It's supported the development of this new treaty on crimes against humanity, including convening a very important meeting here in 2016 that I had the honor to attend. And I hope that the Academy will continue to be able to host additional events as the treaty passes from the early days of its formation, one could say, to actual treaty negotiations. And on a personal note, I could not have imagined we would be where we are today, on the cusp of an international convention of plenipotentiaries to negotiate a Crimes Against Humanity Convention. During the early stages of the initiative 17 years ago, we were planning our first conference, and the outcome of what we were doing was really quite unknown. we faced a lot of challenges over the past 17 years, but the more that I explore the history and the current application of crimes against humanity and the current state of our world, as the other speakers have alluded to, the more convinced I am of the importance of a new global treaty, not just to punish perpetrators, but to prevent the atrocities that are plaguing our world. As the poet Maya Angelou from my own country writes, history, despite its wrenching pain, cannot be unlived, but if faced with courage, need not be lived again. So with that to frame our discussions, I'm going to actually reach into a terrible past before bringing our discussion of crimes against humanity into what I hope will be a promising future. I think that will help us to understand the central importance of how law, and international law in particular, actually matters to the lives of real human beings on the ground and to human society in the larger sense. You are undoubtedly familiar with the transatlantic slave trade that took nearly 13 million African people from their homes between 1501 and 1867. They were kidnapped, forced onto European and American ships, and crossed the Atlantic Ocean in appalling conditions to find themselves enslaved, abused, and separated from their homes, families, ancestors, and cultures. This not only fractured and devastated the African continent for centuries, but turned the Americas into a place where race and color created a caste system defined by inequality and abuse. Slavery and the slave trade were crimes against humanity, crimes that by their cruelty and savagery traumatized not only the victim population, but forever changed for the worse and degraded the perpetrators as well, as Alexandre de Tocqueville observed during his many travels throughout America. And in fact, this goes to the opening comment about, is it a crime against humanity, or is it a crime that degrades our own humanity? And the answer really is both. We know that the slave trade, like slavery itself, was really hard to stop. To do so required moral courage, legal tools, international cooperation, and domestic and transnational enforcement, and a healthy dose of faith. We start examination of the slave trade as a crimes against humanity with the voyage of the Antelope. That might seem like an unusual place to start, but bear with me. On August 24th, 1816, this vessel sailed from Havana, Cuba, under a Spanish flag and a different name, to acquire 350 slaves from traders in West Africa. The vessel had been taken and boarded more than once, and she started her journey back across the Atlantic with approximately 331 enslaved persons in the hold. Many of them died along the way, and many more would perish after their arrival due to the horrific conditions in which they were held. Because the slave trade was by then illegal in most parts, the Antelope could not easily sell or profit from her cargo. But finally, the pirates, essentially, that had taken her, made their way to the coast of Spanish Florida. And as the vessel left Florida and navigated towards Georgia, where slavery was legal, but the slave trade was illegal, it was captured by a U.S. revenue cutter and brought ashore. The fate of the then 258 survivors, whose average age was 14, and more than 40% of whom were between 5 and 10 years old, was unclear. The captives had been taken by Spanish, Portuguese, and American slavers, and the claimants stepped forward from each of those nations, arguing that even if the slave trade had been rendered illegal, the law nonetheless had to uphold the rights of the enslavers. The lower court upheld the claims of Spain and Portugal, but not the Americans. The U.S. government actually appealed on behalf of the captives. The cause was argued to the United States Supreme Court by two famous Americans. One was Francis Scott Key, who also penned the Star-Spangled Banner, which you might have heard, and Attorney General William Wirt. They relied upon a line of British and American cases, including La Jeune Eugénie, decided in 1822 by Supreme Court Justice Story, riding circuit, that the slave trade was contrary to the principles of justice and humanity, prohibited by universal law, and violated both natural law and the law of nations. And here you can see on the slide a depiction of what those vessels would have looked like, bringing those poor, unfortunate souls from Africa to the United States. Now, the Justice Story's opinion in La Jeune Eugénie condemned the slave trade as conceived in atrocious and unfeeling cruelty and stained and sealed with blood. Thus, the appellants contended, as a British court had done earlier in Somerset's case, decided 50 years prior, that because U.S. law prohibited the slave trade, once ashore, the captives were not slaves, but free men. Alas, a closely divided Supreme Court disagreed in an opinion penned by Chief Justice John Marshall, who found the African slave trade is contrary to the law of nature, but not prohibited by the positive law of nations, other than specifically provided by particular treaties that had been entered into by specific states. Justice Marshall did reject Portugal's claim on the facts, but he accepted Spain's, as the Antelope had lawfully set out as a Spanish vessel at the outset. That said, he did manage to free 120 captives. They were returned to Africa, not to their homeland, but to Liberia, where they faced great hardship. Those not returned spent the rest of their lives in bondage in the United States, their stories lost along with their dignity and their freedom. The story of the Antelope is not well known. Much less well known than the vessel, the Amistad, which was many years later, that was memorialized in a gripping film by none other than Steven Spielberg. The Amistad ultimately set aside the Antelope's endorsement of the slave trade, and I'll come to that at the end of the lecture. The Antelope's reasoning persisted for some decades and shaped the infamous Dred Scott case that you probably have heard about, and that actually was decided at first in my city of St. Louis in 1857, that upheld slavery in U.S. territories and denied the legality of Black citizenship in America, a decision that would pave the way for a horrific civil war that killed more American soldiers than World War I and World War II together, 620,000 to 850,000 souls. This was an early example of crimes against humanity in peacetime that led to war, a theme that I'll return to later. Perhaps astonishingly, 200 years after the decision in the Antelope, we can see this case, and in this case, the same tensions that we are experiencing today in the face of atrocity crimes. A Supreme Court that was deeply cognizant of geopolitics, that even in the face of an 1819 U.S. law that rendered the slave trade illegal and likened the slave trader to a pirate over whom universal jurisdiction could be exercised in peacetime and in wartime, nonetheless found that because there were exceptions that existed to the prohibition against the slave trade, it was not truly universal and therefore formed only part of natural law and not international law or the law of nations. But the Antelope and the continued horror of slavery in the United States for some decades to come is not the entire story. These crimes against humanity, as they were widely referred to during the 19th century, were eventually outlawed everywhere, starting with treaties entered into by the British, with the Netherlands, with Spain, and with Portugal. These instruments not only prohibited the slave trade, but included mutual rights of search and seizure between the contracting parties outside the context of war, or what we would now call interstate cooperation and mutual legal assistance. They were backed by enforcement jurisdiction, and they even provided for trials in mixed commissions by treaty courts, including those set up in Sierra Leone, Havana, Rio de Janeiro, and Suriname, which we would now call international and national justice. As Professor Jenny Martinez has noted, slavery and the slave trade were endemic in 1800 and had been completely eliminated by 1900, intentionally by people who had come to believe they were morally wrong. And of course, it was eradicated in part by military force, but also by coordinated international legal action, including the creation of international courts established by treaty. So what does this legal history mean for the development of a new treaty in our era on crimes against humanity? It tells us that treaties really matter. They make clear the obligations of states. They provide for interstate cooperation. They include jurisdiction for courts to adjudicate cases. Without them, we are subject to the whims of judges who may sometimes, like Justice Story in La Eugénie, get the law right, I would say, who reason in one direction. But in others, like the Antelope, we have Chief Justice Marshall, who arrives at the opposite conclusion. So fast forward now to the modern era. What are these crimes against humanity? You've already heard a little introduction from Dr. Safferling. Their legal elements honestly need very little introduction to this learned audience, nor does their modern history. The term is generally attributed in our time to a meeting between Herr Slaughterpact and Justice Robert Jackson, as beautifully chronicled in Philippe Sand's extraordinary book, East-West Street, which was performed in this very courtroom in 2016. However, as I've already alluded to, the concept has a much earlier and prior long history as a description of slavery and the slave trade, King Leopold's atrocities in the Congo, and the massacre of the Armenians in the early 20th century. It was enshrined in the Martens Clauses of the 1899 and 1907 Hague Treaties, which provided that until there was a more complete code of the laws of war, that is, more positive law, the high contracting parties deemed it expedient, I love the old language, to declare that in cases not covered, the inhabitants and belligerents remain under the protection and the rule of the principles of the law of nation as they result from usages established among civilized peoples, from the laws of humanity and the dictates of the public conscience, and thus were morality, natural law, and the law of nations unified in this important preambular paragraph. And I'm going to show you a picture, actually, of the room in which the 1907 Hague Conference was called for, and this Martens Clause was then the result of that. It's actually on my university's campus. So these crimes materialize much later in this courtroom as Article 6C of the Nuremberg Charter, and were adjudicated by the IMT, as you've already heard, in its judgment, as well as by the Tokyo Tribunal. They're mass crimes that may take a variety of forms: a state policy of torture or disappearance, a campaign of rape or other forms of sexual or reproductive violence, arbitrary arrest and detention, typically accompanied by inhumane conditions, mass expulsions or deportations, often referred to as ethnic cleansing, or mass murder of individuals by a government or non-state actors in war or in peace. As the late Antonio Casese observed, they're characterized either by their seriousness and their savagery, by their magnitude, or by the fact that they're part of a system designed to spread terror, or that they are a link in a deliberately pursued policy against certain groups. Over time, 4 key features have emerged from the jurisprudence of the ad hoc tribunals and the ICC relating to crimes against humanity. First, they protect all civilians, including a state's own nationals, from widespread or systematic attacks on their human rights that rise to a certain level of seriousness. Second, unlike the crime of genocide, although the crime against humanity of persecution addresses attacks undertaken on a discriminatory basis, persecution or discrimination is not a necessary element of a crime against humanity, although it is often present. Third, the perpetrators of crimes against humanity may be state or non-state actors, including, but not limited to, organized armed groups. Fourth, unlike war crimes, and this is critical, crimes against humanity may be committed during armed conflict or during peacetime. The Rome Statute added one more element, which is not found in the iterations of the crime in earlier incarnations. Article 7.2a specifies that the state or organization committing the attack against the civilian population has to be doing so pursuant to a policy, although the policy need not be formal or in writing. The Rome Statute definition in Article 7, which will undoubtedly become the centerpiece of the new treaty, was obviously much more extensive than Article 6c of the Nuremberg Tribunal. So why is preventing and punishment of crimes against humanity so important? The expansive ambit of this crime makes it a powerful tool to address something that I call an atrocity cascade, and hopefully you can read the slide. The print is not too small. Atrocity cascades, and for those of you familiar with Catherine Sicking's work, you'll see this is a riff on the justice cascade, right? Atrocity cascades are bad, right? Justice cascades are good. But atrocity cascades basically are situations in which you have a country or a region in which human rights abuses are becoming prevalent. They then deteriorate to the point of becoming criminal, and if not staunched, can descend further even into war or into genocide. And I have a picture of this on the slides. Prosecutions based on crimes against humanity can occur before the onset of war or the commission of genocide, rendering crimes against humanity charges a potent tool for mass atrocity prevention. Human rights violations occur in every country in the world. Most national systems have mechanisms to address them, however, and fortunately, they tend to be sporadic. So addressing them typically falls in a country's own national system. There are a whole series of treaties and institutional mechanisms that address human rights issues at the international level as well. However, sometimes both the national and the international checks on human rights abuses fail, and they can grow and metastasize, overwhelming the ability of national systems and human rights mechanisms to address them. And if they reach a certain level of seriousness, they become crimes against humanity. There's thus a frontier, if you like, a threshold between human rights violations and criminality in peacetime, which you can see on the slide, where combating impunity for the commission of crimes against humanity becomes so important. And I really thought deeply about this peacetime component and the peacetime importance of crimes against humanity through my work at the International Criminal Court, where I was as a special advisor for 10 years. And you can really see this in the work of the ICC, and you could also see it in my example of the transatlantic slave trade, which was a peacetime crime. The ICC, being the world's first permanent international criminal court, it's the one court that can operate in real time. Crimes against humanity have been alleged in all the situations referred to the court and in most of the cases. In situations involving armed conflict, crimes against humanity charges often track the war crimes charges or are added to target persecution or sexual violence or to fill gaps in the laws of war. In many situations, however, like Venezuela or the Philippines, as evidenced by the recent arrest warrant against former President Rodrigo Duterte, the crimes against humanity charges are the only basis upon which the ICC can act, given the absence of an armed conflict sufficient to trigger the court's war crimes jurisdiction, and the implausibility of alleging genocide. Thus, crimes against humanity actually can serve as an important tool of genocide prevention, applicable before atrocity levels spin completely out of control to reign in a situation that is deteriorating into conflict or overwhelming levels of atrocity crimes. Sadly, where the ICC has no jurisdiction and the Security Council process is blocked, neither prevention nor deterrence are present, as shown by the terrible toll of the civil war in Syria. And Syria is an emblematic example of this kind of atrocity cascade in which human rights abuses happen, crimes against humanity start to appear, and it gets so bad that the opposition forces arm themselves, it deteriorates completely into a civil war, and you have within that field pockets of genocide, such as the siege of Kobani and other incidents. In a study I published in 2013 in the American Journal of International Law of the 8 situations then before the ICC, it was Central African Republic, Cote d'Ivoire, Darfur, Democratic Republic of the Congo, Kenya, Libya, Mali, and Uganda, crimes against humanity charges represented the only charges by the ICC prosecutor in 3 of those situations, and the number of accused charged only with the offense of crimes against humanity represented more than 1/3 of the court's cases. Contrast that with the ICTY and ICTR, where there were only 2 accused at each tribunal charged solely with crimes against humanity, representing 1.2 and 2.2%, respectively, of all accused. This difference in the practice of the ICC and the ad hoc tribunals is really striking. But why a new treaty, right? Given that we have the ICC with 125 states parties and others thinking about joining, and we had the codification of the text of Article 7 in 1998, why a new treaty on crimes against humanity? First, we predicted in 2008, and we were correct, the ICC is going to take very few cases. This was a prediction, it's a clear reality. Second, and sadly, we're now experiencing a resurgence of these crimes around the world. Third, there's no duty in the ICC statutes for states to criminalize the offenses in the Rome Statute, although they're encouraged to do so, and there's no duty to prevent crimes against humanity in the Rome Statute. So that makes crimes against humanity at the ICC critically, outside the ICC, critically important. And in fact, an ounce of prevention is worth a pound of cure, as we like to say in the States. This requires strengthening state capacity and imposing an enforceable duty of preventing crimes against humanity on states, parallel to the obligation in Article 1 of the Genocide Convention. The duty to prevent was the subject of a really important judgment of the International Court of Justice in Bosnia versus Serbia, but is not expressly present for crimes against humanity because there's no global treaty on these crimes. And finally, as alluded to earlier, in order to effectively investigate, prosecute, and deter crimes against humanity, states need to be able to cooperate with each other and offer mutual legal assistance. The ICC offers a vertical mechanism for the prosecution of these crimes, and in contrast, the proposed Crimes Against Humanity Convention will be interstate, offering a horizontal mechanism for prevention and punishment. This will close a gap that has persisted for nearly 80 years. Thus, the absence of a specialized convention leads to an impunity gap, a state responsibility gap, a lack of state cooperation, and definitional uncertainty, as well as no duty to prevent. So, I started in 2007 and 2008 something called the Crimes Against Humanity Initiative, directed by an international steering committee of luminaries that helped shape and direct the project. And this is a picture in the famous room that I'm going to talk about at the end of the lecture. Through an iterative process, and this was our very first meeting in St. Louis in 2009, we held meetings in St. Louis, in The Hague, in Washington, D.C. We put out a call to 250 individuals overall worldwide to give us input into the drafting of a new model treaty on crimes against humanity, and we eventually published our work as an academic project along with a treaty. You can find the proposed convention on the Harris Institute website still. We based our work on the many international criminal law treaties already in existence, such as the Genocide, Torture, Apartheid, and Enforced Disappearances treaties, and took as the definitional centerpiece for the model treaty Article 7 of the Rome Statute. The 27 articles and 6 annexes of our draft convention is available in multiple languages, including German. It was actually translated into German for free by a colleague. The project rested on the 4 pillars I've alluded to earlier. First, normative development, that all human beings have a right to be free from the commission of crimes against humanity. And that's something that a victim from the Democratic Republic of the Congo said to me. When she heard about this treaty, she said to me, I never realized that I had the right to be free from the commission of these crimes. Second, prevention. I've already talked about the obligation of prevention. It's in the Genocide Convention. It doesn't exist for crimes against humanity. Third, in order to implement and make state investigations and prosecutions viable, as well as to enhance prevention, we thought it was very important to include capacity building measures in the treaty itself. These could include provisions on transfer of funds, the establishment of a treaty monitoring body, as well as requirements for police and military training and human rights protections. And finally, one needs robust interstate cooperation mechanisms. Our proposal was to enhance the de minimis provisions of earlier treaties on genocide and war crimes and establish a series of robust provisions on extradition, cooperation, and mutual legal assistance, more like those found in the transnational and organized crime treaties. Those appeared as annexes to our proposed convention and were eventually incorporated into a different project known as the Mutual Legal Assistance Treaty that you've heard of here today, which was negotiated outside the UN system and adopted in Ljubljana in May 2023 and opened for signature last year. The ILC also followed our approach in its 2019 draft articles on crimes against humanity, to which I now turn. I am getting to the current day. So in 2010, the Crimes Against Humanity Initiative held its capstone conference at the Brookings Institution in Washington, D.C., and as luck would have it, Professor Sean Murphy of GW Law School attended and indicated an interest in our work. Sean Murphy was subsequently nominated by the United States as a candidate for the UN International Law Commission, and when elected to the ILC in 2012, proposed this topic to the Commission, which adopted it and then fast-tracked it 2 years later. Thereafter, Professor Murphy served as the Special Rapporteur for Crimes Against Humanity from 2014 to 2019. In 2014, we hosted a conference to support the work of the Commission on Crimes Against Humanity. Here we're all standing in front of another famous venue. This is the Villa Moignet in Geneva, a storied venue as well. And for years, the Commission worked by Professor Murphy, producing a report, drafting some articles. The Commission's members would then debate that during the summer, send it to the drafting committee. At the end of the summer, the work would then be adopted and sent to the UN General Assembly's 6th committee for consideration. And this iterative process, which was essentially a dialogue between the Commission and states, because states were offering feedback to the Commission's work every year, continued until in 2017, a semi-final set of draft articles was published, sent to states for comment in 2018, and then revised in 2019. And in 2019, the Commission adopted a second set of draft articles on second reading, and I've summarized them just a little bit. I hope you can read it a little bit. So you can see that they've taken Article 7 of the Rome Statute as the centerpiece for the draft. They've amended it, by deleting the definition of gender, and I'm going to come back to the fact that this has been a female-led process to some extent. They got lots of comments asking them to delete the definition of gender, and they did. They made some other changes with maybe we're happy with, maybe we're not. I think there's going to be some negotiation about that. And then you can see that there's a whole set of obligations. There were 15 articles. I'm not going to go into them all. They set out an obligation of prevention, non-refoulement, criminalization under national law, establishment under national jurisdiction, investigation, etc. And there's an annex on mutual legal assistance. So 2019, the Commission finalizes its work and actually then recommends to the General Assembly that they be turned into a treaty. There are other possibilities for Commission products. They can become guidelines or other sorts of things, but the Commission actually, and my husband actually said, was it really the 3,499th meeting? And it was. It's taken that long since the UN Charter was established to get the final draft for the Crimes Against Humanity Treaty, and it recommended the elaboration of a convention either by the General Assembly or by an international conference of plenipotentiaries. So you can imagine, as the project director, I was super excited about this. Yay, we have a draft, we're going to the 6th committee, and when we got to the 6th committee, everybody was super excited about this, right? Everybody's here in various buildings, in various conference rooms, and a significant majority of states in 2019 were willing to proceed quickly to a diplomatic conference to negotiate the treaty, which Austria offered to host. A handful of states demurred, asking for more time, and an even smaller number opposed the treaty entirely. Because of the consensus tradition in the 6th committee, which allows even a small number of states to block action on a particular proposal, the result was somewhat disappointing. It was a resolution, quote, taking note of the draft articles and promising to revisit them the following year. Austria, accompanied by 42 other states, expressed its disappointment. In 2020, the result was even worse because of the COVID-19 pandemic, which made the working methods at the United Nations very, very difficult. And we got, again, a technical rollover resolution. And one of the things I've been doing every year since 2013 is actually tracking the position of every state with respect to the draft, with respect to every iteration of the draft. So you'll see a few of these slides. This time, Mexico objected to the technical rollover, voicing concerns that this risks this getting caught in a sort of unending cycle. In 2021, with the waning of the pandemic, expectations are now running high again in New York as state interventions in the 6th committee were again overwhelmingly positive. A handful of states opposed any action on the draft articles, and because states supporting the draft articles were unwilling to put the matter to a vote, the result was another technical rollover to 2022. Frustrated, this time Mexico dissociated from the resolution, and other states objected, including the United States, the UK, Israel, and the EU. And the EU made a particularly strong statement objecting to the infelicitous cycle that was sort of plaguing the inability of the 6th committee to advance this, which it felt was impairing both the legitimacy of the ILC and the 6th committee itself. And this is 2021. You can see more states speaking positively, but still not able to break through this barrier of consensus. And you can guess which states were objecting. And it wasn't the United States, just saying. So in 2022, we get a breakthrough. And determined to avoid a repeat of 2021, a cross-regional group of 8 states, Colombia, Costa Rica, Gambia, Mexico, Korea, the UK, and the United States, deposited a 0-draft resolution with the Bureau on October 5th, right before the start of the 6th committee session, which had been scheduled for October 10th on crimes against humanity. Such a resolution could have led to a vote, a result most states wanted to avoid. This procedural innovation, which Mexico's legal advisor has referred to as flipping the tortilla, because, that's a quote, because they actually introduced it early, had the effect of pressuring states to find a way forward by pressuring them, holding the possibility of voting out to the side. Mexico and the Gambia acted as co-facilitators. During the initial plenary debate, the zero draft received considerable support, and after weeks of really difficult negotiations, during which both co-facilitators and the opponents showed some flexibility, a modified draft was created, Resolution 77/249, which provided for an inclusive, structured, and transparent process to take the draft articles forward. At the same time, we did lose some elements. The time period for discussion was extended from 1 to 2 years. It wasn't going to be an ad hoc committee anymore, but the sixth committee acting in interactive format. And most worryingly, it remained inside the sixth committee until 2024, meaning that we might just have put off the blockage because the sixth committee wants to operate by consensus. So we possibly had just lost 2 years. But what was amazing was that this resolution was actually adopted this time with 86 co-sponsors and a total of 100 states supporting the draft in some measure. And I'm going through all of this history because I think it gives you a sense of the amount of work and focus and perseverance it does sometimes take to get work like this done. The thing that was wonderful is after we opened this 2-year window, we had these wonderful meetings that Germany hosted in February and March of 2023 and 2024. We held the sixth committee resume sessions in April, and they were skillfully facilitated by co-facilitators by eliminating general debate. They divided the draft into clusters, and they imported from the International Law Commission the practice of having mini debates so that states could really engage with each other. And this was a way of not just having a substantive and technical discussion, but building a rapport. Because what it takes to get this done is honestly for people to trust and to like each other so that they're willing to work through some of the difficulties. You can see in 2023, we have even more positivity. Sorry if the numbers are a little small. But we can see increasing numbers of states kind of getting excited about this and moving forward. So now we come to 2024, right? This is the year that the resolution 77/249 set as the year to go forward. And once again, in September, Mexico and the Gambia, on behalf of a cross-regional group of states, again table a zero draft prior to the scheduled meeting of the Sixth Committee on Crimes Against Humanity. The zero draft set forth a concrete and time-bound process for negotiations through the convening of a UN Conference of Plenipotentiaries on the prevention and punishment of crimes against humanity. And I have to say, when I read operative paragraph 4 of that draft, I might have cried just a little bit, because it was the first time really we'd seen states affirmatively calling for this. This time, the state interventions were extensive. 102 states inscribed on the list. 142 states were represented in that inscription, including multiple representing regional or cross-sectional groups. And a tally of the interventions made showed strong support for moving forward to negotiations, this time with 125 states expressing positive views, 7 were neutral, and 13 were negative. And importantly, several states that had been negative previously, including Egypt and Nigeria, had shifted and were now positive in the 79th session. Sierra Leone, delivering a cross-regional statement on behalf of 77 states, was also in the forefront. There were some states arguing they still needed more time for study and to resolve differences, but most states agreed with Brazil, for example, who said there's never going to be an ideal moment for this, and time is of the essence when it comes to human dignity. Other states urging delegates to move forward, including Jordan, Portugal, the United States. Sierra Leone offered to host a diplomatic conference. Remember, Austria had already offered to do that. Ireland, Peru. Cabo Verde delivered a statement on behalf of Portuguese language countries, et cetera, et cetera. And really, by the end of the session, you could see that most states understood that the way to resolve their differences was to proceed to negotiations rather than this endless cycle. You know, occasionally the voices of the victims actually echoed throughout the room in the United Nations headquarters in New York. South Africa echoed its own painful and wrenching history with the crime of apartheid. The current ambassador for Afghanistan, who doesn't represent the Taliban, referenced the scourge of gender apartheid. Sierra Leone spoke to the horrors, continuing legacy, and modern-day iterations of slavery and the slave trade. Bangladesh, Israel, Myanmar, and the state of Palestine also spoke personally as well, speaking to painful experiences in the past and the present. Poland condemned attacks on children, and Nigeria underscored the need to address crimes of concern to African states, including environmental crimes, colonialism, and emphasized the need for reparations. At this point, the very few states maintaining their opposition included the Russian Federation and China. On November 22nd, 2024, after an exhausting and dramatic day of negotiations conducted in person and by WhatsApp chat, the Sixth Committee adopted a draft resolution co-sponsored by 99 states by consensus. And you can see in this slide, where I'm tracking it from 2013, how we managed to build consensus and support over time. Little by little, state by state, every year we would tabulate, and every year we would work on those states that hadn't yet decided this was the right thing to do. On December 4th, 2024, that resolution was then adopted by the UN General Assembly as Resolution 79/122. And this is the roadmap of what's next. It sets out a framework to move forward over the next 4 years with a working group on the conference and preparatory committee meetings starting in 2026 and 27, and a diplomatic conference to take place in 2 3-week sessions in 2028 and 2029. Heading into November 22nd, we did have a stronger text with more streamlined process and timeline and very robust civil society participation on the table, but last-minute compromises were made, largely due to pushback by the Russian Federation, which infuriated some delegations given that Russia finally dissociated from the text. That said, even if our final text is not as strong as the initial zero draft, its passage by consensus by both the Sixth Committee and later by the General Assembly sets the stage for inclusive negotiations for a treaty with universal acceptability. And while the text prolongs the process, it preserves the core elements of the zero draft, and its adoption was honestly quite an extraordinary moment. There was widespread applause in that room. So, moving forward, the struggle to draft and win state support for a new treaty on crimes against humanity, against the backdrop of a world on fire with their commission, has been a long one, with many players and many partners. Some have been states that, like Great Britain's quest to abolish the slave trade in the 18th and 19th centuries, have been willing to take the lead in galvanizing world opinion. Germany has played a significant role, hosting intercessional meetings and supporting this effort from the beginning. Others have been legal experts, UN officials, members of civil society, including survivor and victim organizations. The Global South has led the process, a very hopeful sign for the outcome of this treaty. And women and gender organizations have been at the forefront from the get-go, seeing in this treaty the possibility of completing a huge gap in the framework of atrocity crime prevention. So now comes the real push for the next 5 years, when at last the substance of the new treaty will take shape. The 2019 draft articles provide an excellent starting point for negotiations, but we still have questions on the table. The chair's summary report of the 2 April resumed sessions include many comments from states relating to the text, as well as the comments already submitted by governments, which now have the opportunity to submit further proposals by April 30th, 2026. Questions have been raised about the absence of a Martens Clause in the draft preamble, the unusual drafting of the definition of persecution, the possibility of adding incitement to the text, including a definition of victim, enhancing the fair trial rights included in the text, and many states have supported the creation of a treaty monitoring mechanism of some sort. questions of amnesties, immunities, the addition of new crimes, and important questions of treaty design in terms of reservations, dispute settlement provisions with an ICJ compromissory clause, and the geographic scope of the duty to prevent must also be addressed. As I mentioned, states have an opportunity to submit formal proposals for inclusion in the compilation that will go to the diplomatic conference until April 30th of 2026. So now is the time for study, preparation, and even drafting. Of some concern to me is the deleted provisions ensuring robust civil society participation, which did get eliminated from the zero draft as negotiations intensified last fall. We saw during the 6 years that the draft treaty languished in the Sixth Committee that CSO participation was critical to moving forward. When we could get in the room, the dynamics completely changed. Under Resolution 79/122, while ECOSOC accredited organizations will still be able to participate in the preparatory committee and the conference, the participation of non-ECOSOC accredited organizations and other stakeholders is going to be decided through an as yet undefined process by the PrepCom, which is going to start meeting next January. More than 650 experts and civil society organizations signed a declaration urging states to take the treaty to negotiation last fall, and the civil society organization Avaz organized an online petition that got more than 500,000 signatures in 3 weeks. So civil society wants this treaty. And strong advocacy will be needed to ensure that a broad and diverse section of civil society can meaningfully participate. At the end of the day, the real beneficiaries of this treaty will be those who receive justice or who don't become victims of crimes against humanity to begin with. We don't know how many will benefit, and we can't hope to stop all crimes or punish all perpetrators. Returning, however, full circle to the beginning of my lecture, we can learn from the experience of the slave treaties and courts of the 19th century. The U.S. Supreme Court's decision in the Antelope allowed the trade to continue for another 40 years, a stain that would only be removed in 1841 when Justice Story, back in power, again had the upper hand and decided that captives brought into U.S. waters and freed on U.S. soil were free Africans, not slaves. As for the 19th century treaties and treaty courts, in situations where slave ships could be interdicted and their prisoners released, some of the ill effects of the slave trade were mitigated, and the trade, as I said, was steadily abolished. The court system set up in Sierra Leone, in particular, resulted in the emancipation of approximately 65,000 enslaved persons between 1819 and 1846 and held more than 500 trials. Eventually, the courts acquired jurisdiction over slave ships that did not yet have cargo, leading to estimates that they saved perhaps another 90,000 persons from enslavement. Perhaps it's no coincidence that one of the key amendments driving Global South support for this new treaty is the addition of the slave trade in Article 2.1c's incrimination of enslavement, which is kind of a no-brainer. It's also an amendment at the ICC. But it is a key to righting a terrible historic wrong. As one of my civil society colleagues noted at a side event that was held in The Hague last December, this new treaty and the hope it represents is not just a piece of paper, it's a promise to survivors. History tells us that its adoption will be a necessary but not a sufficient first step in preventing and punishing crimes against humanity. Without it, we're missing a critical legal tool, as the 19th century experience shows us. With it, we have at least a chance to save victims, save survivors, and save ourselves. As my fellow countryman Robert Jackson argued in this very courtroom nearly 80 years ago, civilization asks whether law is so laggard as to utterly helpless to deal with crimes of this magnitude. It doesn't expect that you can make war impossible, but it does expect that your juridical action will put the force of international law, its precepts, its prohibitions, and most of all, its sanctions on the side of peace. Even once the treaty is adopted, the work will need to continue. A ratification campaign will need to be undertaken, and enforcement by states will be critically important. I suspect, unfortunately for me, the most difficult part of the journey probably lies ahead, not behind, particularly given the current geopolitical environment that's been alluded to. Yet we do take heart from the example of the horror of the transatlantic slave trade, that although the arc of the moral universe is often painfully long, it does indeed bend toward justice, as the Reverend Dr. Martin Luther King reminded us in 1965. I hear Ben's voice in my head with his usual admonition, never give up, never give up, never give up. We can all say it together. And I was actually in The Hague on December 4th, attending the ICC ASP, watching on my phone the debate on Resolution 79/122, and I stopped by the ICJ and I sat on Ben's bench as the General Assembly actually gavelled in that resolution. So even though there's a lot of work that still needs to be done, at this juncture, it seems appropriate to pause for a moment. And I wouldn't call it a victory lap, but at least express tremendous gratitude for the adoption of a resolution to convene a UN diplomatic conference of plenipotentiaries on the prevention and punishment of crimes against humanity that now has an official website. It's on the UN website, which makes it very exciting. And it received support from 192 out of 193 states in the UN General Assembly and in the Sixth Committee. I'm privileged to have been an integral part of this journey, a small part of a very long arc of history. And here I just have to show you, I don't know if you can read the text, but on my left, on the left, you can see the room on our campus where the Interparliamentary Union actually met to convene in 1904 when St. Louis was a major city. It's now not a major city. But then the World's Fair was held, and they actually called for the calling of a second Hague Peace Conference in that very room. And we held our first meeting there, and then just last week, we have Mexico and the Gambia's legal advisors sitting in the same room with some of us and my students. We have swag, we have t-shirts, we have wristbands, because we got to stay motivated for the next 5 years. And I'm just so grateful to the entire team that for 17 years has sustained this expert, including many of you, the Nuremberg Academy itself, the German government, and all our friends and partners all around the world. I thank you so much for your kind attention and look forward to your questions.
Leila, thank you so much for this outstanding speech, really giving us the full picture of, going back to history and in particular judgments on slave and the slave treaty, and up to now these recent developments, very exciting developments, and we are very pleased to have you here to report on these developments firsthand. So Leila has thankfully agreed to take a few questions. So I'm looking around. I don't want to abuse my role here as a moderator. We have a question here, over here. There are 2 microphones. I can give you mine.
Thank you very much, and thank you very much, Professor, for your very, very interesting lecture. I have great pleasure to introduce myself. My name is James O'Shea, not O'Shea, the Consul General of Ireland, not the Republic of Ireland, from Munich. And my question is born from practical experience in that I had the honour to be part of a number of newly elaborated instruments of international law, mainly the Convention on Cluster Munitions, which was negotiated in my own home capital city of Dublin, 30th of May 2008. My question relates to the procedure by which this convention will be elaborated and adopted. Would it be correct in thinking that the decision-making will be worked out by the preparatory committee? Is that the way it's going to work? Because it's a key issue of not just the procedure, as you know, but of whether it's going to be possible to achieve a strong convention, and there are different arguments. I mean, a weak document by consensus as opposed to a strong document by vote, which is more valuable, is something which will have to be debated probably. But just if you have any particular perspectives on that, or just the factual, forgive my ignorance, what might be specified already in the documents adopted. Thank you.
Should we take a couple questions? Do you want me to answer each one? That one I can answer very quickly.
Go ahead.
But, okay, because I talked a lot. So the resolution was heavily negotiated, and obviously what Mexico in particular and Gambia wanted was the Conference of Plenipotentiaries would use the normal rules of the General Assembly in which voting is the default, right? So that is in fact what is in the resolution. But then there's a very strange paragraph that talks about how they will strive, I can't remember the exact word, they'll strive for consensus. So that was a debate, but in fact the rules will be the normal rules of the General Assembly. We have finally escaped the gravity of the Sixth Committee and the consensus rule. Yeah.
Thank you for now. Are there further questions in the room? Yes. So please introduce yourself quickly.
Yeah. My name is Joe Hamburger. I'm the president of the Jewish community in Nuremberg. I'm an amateur compared to you, and I've been infected by my son who is studying law with Professor Safferling, so I'm daring to ask a question which might be stupid or simple. There's a complex question with regard of international law and custom international law. One is treaty law, correct me if I'm wrong, and the other one is a non-written kind of custom international law. This is one of the challenges which has been brought up lately when we talked about in Germany about the warrant against Netanyahu and Galland. And in terms of has Germany to apply this law, and do they need to be imprisoned in Germany or not? And this conflict, is this a real conflict you're aware of today when you talk about the application of the international principles? Do you understand what I mean?
Yeah, absolutely.
More or less, is this making sense, or?
Well, and I don't want to give a big lecture on it because there are a lot of things embedded on that. But essentially, crimes against humanity following the Nuremberg trial, right, were said, they were codified by the International Law Commission as part of these principles, and they existed as part of customary international law. The difficulty is that states can't, most states, right, common law states, we need a statute. And in order to cooperate with other states, we need treaty relationships, and we need to set out jurisdiction, because international crimes have very different features than ordinary crimes in most legal systems. So in order to, if you want to say implement the custom, make it real, that's where you need the treaty relationship. The crime still exists as a matter of customary international law. It didn't go away after the Nazis were prosecuted, but it makes it very difficult to operationalize it without a treaty dedicated to its prevention and punishment. Now, the ICC is a totally different question. The ICC is a treaty court that has included in Article 7 what we believe, I personally believe, the definition is customary international law in Article 7. And I think that that's, Klaus Kress agrees with me on that. Not everybody does. But I think that there are...
What if the two of you agree? Thank you.
The thing is that the ICC, because it can, the Security Council can use it, right? ICC law can be applied to any human being on the planet. And that was true in the Omar al-Bashir case, that was true in the Libya situation. Through the Security Council referral, the Security Council can refer situations to the court that then empower the ICC prosecutor to investigate and prosecute. And that's really only possible because the law in this statute is considered to be part of customary international law. And that's important for fairness to the accused, right? That the accused understands that that law is there. It's why we were able to create the ECCC, the courts for Cambodia, using the same law. It's why we could create the special court for Sierra Leone. These are situations where the national system didn't have a law on crimes against humanity, and so there needed to be an international court. And the international courts do use the customary international law definition, and then their treaty has the mechanisms by which the treaty operates. You have some experts on the ICC here who could talk about how that works in practice. But it's a great question.
Thank you. Then I have two more questions, and maybe we take them together to give you a little bit of a pause.
Yeah, because I talked a lot, sorry.
Okay, this? Yeah. Okay. My question is, with which arguments and what are the reasons? I'm here.
There you go.
Which? Oh, I'm Dorothy Weidbrecht, director of the Elisabeth Käsemann Foundation. With what arguments and with which reasons countries like Egypt, in which the human rights situation is fragile, you convinced to support the treaty, the coming treaty. This is very interesting that you convince many regions in which the human rights situation is fragile, that they will obviously are tending to support this new treaty. Thank you.
If you want to.
Yeah, let's take a couple more questions, because,
Then pass the microphone on, please.
Rainer Hulle, and perhaps what I should say about me in this context is that I was for 8 years a member of the Committee on Enforced Disappearances of the United Nations, and that's where we, not only myself, but all my colleagues, had some trouble with the draft of this convention. The trouble is, you know it, but I raise it anyway, that it seems to fall behind the drafting of the specific Convention on Forced Disappearances, orienting the draft mostly on the ICC statute, which is older and not so innovative and advanced as the specific convention. So that's a general question, perhaps. Does the draft perhaps devaluate some more specific human rights treaties by combining it all under the umbrella of crimes against humanity? And my second question is, what do you expect about the ratification process? I mean, the latest international conventions have not such a enthusiastic drafting ratification record. So in case it's only half or a third of the UN states ratifying that convention, would that not be a setback? Because we have crimes against humanity as customary international law already, and it is applied in many contexts, but it might be for national jurisdictions perhaps a good reason to say, it's not all so unified in its recognition. These are two concerns. I just think it would be valuable if you could give us your thoughts about it.
Do you want to go ahead, or I have one more question?
One more question, yeah.
Thank you very much. Thank you, Professor Sadat. It was really a vivid presentation, and you see, or we all feel your dedication to the topic and all these narrow changes during the years. My question would be: in the UN, we often witness some proxy debates which are not on the substance, but maybe a kind of misuse of unanimous vote and so on. My question would be, do you have the impression that on your case, it's for the last steps, it's really on the substance of the text of like all the problems you described? So, because is the solution in there, or is it finally then with the last maybe 2 or 3 opponents just to get their vote? Is it on a higher level because it's just to get something totally different from this you talk here? So as we see often, it's a question of how UN works in these, also in the 6th committee with unanimous vote. Is it misused here, or do you think you find a solution on your text finally?
Oh, those are all great. They're sort of all great questions. So, and I think I can answer them by unpacking a little bit because I painted with a pretty broad brush. So in the UN General Assembly, you have states that are parties to the Rome Statute, and you have a lot of states that are not parties to the Rome Statute. All of them are considering this definition of crimes against humanity. So Egypt is a non-state party. Many states that were not states parties would raise, and this sort of goes to your point, are they raising real objections or are they just trying to stall the process? And sometimes it's both, right? Some of the non-Rome Statute state parties were arguing about the definition itself. Or you'd hear, well, we need more time. This is too serious a subject to do, and we don't, China in particular talked about the methodology of the commission, this sort of thing. Other states, I think, were just opposed because the Russian Federation took a very hostile approach to this document from the get-go. Really hostile. And it pulled a lot of states with it. I think once we got the breakthrough because of two political developments, one was the war in Ukraine, where their really diplomatic credibility was much, much less. There was also a lot of engagement by Global South states and by European states in their respective communities, right? The ICC states parties stopped seeing this as a problem or a threat or a difficulty and realized that it would actually enhance complementarity. And the non-states parties or Global South states, even if they were, could see things in this treaty for them, right? To go to your point, I think the definition is going to be reopened in a modest way. Initially, we heard many states say, no, you can't touch it. And our project and the ILC, remember this goes all the way back to 2008, the ICC statute was newly minted, nobody would have touched the Rome statute, really. Now you're hearing many states, including ICC states parties, talk about the need for thoughtful and modest amendments. We've had proposals for including forced marriage into the text, environmental crimes, slave trade, not shocking, it's in the 1927 treaty, for goodness sake. It seems like it was just forgotten, to be honest. Enforced disappearance, Amnesty International and others have come in with a very strong paper saying we don't like the definition. So I think we are going to see some massaging. I've done a paper on environmental crimes, and I think there's going to be some opportunity for creative development within the constraints of the politics and the geopolitics of the time. I was very disappointed so Egypt, part of it was luck. We had been working a lot with Egypt's legal advisor. Egypt sees itself as a leader in the Arab world, and so it was very influential and very negative. During the first debate, they talked a lot, and they didn't say very nice things about the treaty, and you can see that in the coding that I did on Egypt. That was the other thing. States didn't like it if we didn't code them green. They didn't want to be coded red or orange. I had one state come up to me and say, why did you code me yellow? We support this. So what happened is the politics started to change as it became, 50 states, 60 states, 70 states, 100 states, 125 states. Do you really want to be the state that puts a stick in all of that? And with Russia sort of losing some of its political clout, and honestly, the state of Palestine was very influential, especially with the Arab group and with Iran. They worked the floor. They were very committed to the treaty. Lots of states that you wouldn't expect, Gambia, Mexico, I think you would expect, Sierra Leone, lots of enthusiasm and support came from all different quarters. And then Egypt's legal advisor changed, and it turned out to be a former student of Sharif Bassiouni, who took over as the legal advisor, and he and I went and had coffee, and I'm texting him, like, do this for Sharif. Come on, you've got to get this done. So, of course, everybody has instructions from their governments, but they have a certain degree of personal agency, and how you carry out your instructions can be different depending on how you feel about the process. So we had huge statements after the resolution was adopted by Iran, by Ethiopia and Eritrea, states that do not have excellent human rights records, saying how important it was that the Sixth Committee had spoken with one voice and adopted this. I do think the geopolitics is influencing everybody, and in that room, it was hard not to feel that this was something important, and it was more important to be part of it at that moment than to put a stick in it and try to stop it. It just took a really long time to get there, and it took some luck, and it took a lot of lobbying.
Thank you so much for these insights into deliberating and debating. I have another question back here. Are there more hands up somewhere? Okay, please go ahead.
Thank you. Thank you, Professor Sadat, for your insightful presentation. My name is Katerina. I'm doing postdoc research here in Friedrich Alexander Universitet, and also I'm representing Ukrainian human rights community. And by this occasion, thank you very much for enhancing capacity of Ukrainian law enforcement and your very important contributions. My question is that you talked about some consensus today on different provisions of the draft convention, and one of the key features of this convention is the liability of legal persons, and supposedly businesses are much about business complicity. During the Rome Statute negotiations, the corporate and legal persons' liability did not get consensus. In the case of convention, how do you assess the consensus of states around criminalizing legal persons' complicity in crimes against humanity?
Yeah, that's a great question. I was actually at the commission when it was being debated at the ILC, and the commission was split on whether to include liability for legal persons in the draft. And there were some very, very influential members of the commission that argued very forcefully for it. The special rapporteur didn't initially want it in, but it did go in once the drafting committee, they have a deliberative process at the International Law Commission, and they decided to put it in. It's not the subject of much debate in the Sixth Committee. Of course, for the first 4 years, we didn't debate anything until we finally got the substance. And I think most of the debate was positive, actually. I think many states aren't really paying attention deeply to the details, but I suspect that part of the ILC draft will survive because it is an innovation, but it's 25 years after Rome, it seems very appropriate to have these kinds of things. And it's only liability if your state already has the possibility of liability. So it doesn't require a state to create a new category of international criminal. It only says if you have this category, if you have this possibility, I'm paraphrasing, but that's basically what it says, is if you can do it, you have to do it if you ratify this treaty. I mean, I think where the negotiating is going to be tough, reservations, ICJ compromissory clause, duty to prevent. The duty to prevent provisions are a little woolly in the ILC draft, and I think states are going to have to take a hard look at those. I think the definition, there will be some amendments to the definition. Yeah.
Thank you. Then I have two more questions.
Thank you. My name is Andreas Kyriakou. I used to be an NGO delegate at the Human Rights Council in Geneva for a number of years. I joined in 2019. That was 1 year after the US had withdrawn. And then they stepped back in after the change of government. Now we've got to change again. And current US government is, of course, on one hand withdrawing from all sorts of UN institutions again, but has now also started to side with Russia in very important topics and votes. In the first Trump government, it seemed a bit that the delegates from the US had quite a lot of agency. They could still, at the Human Rights Council, they had withdrawn, but in other institutions, they remained. Now it seems as if there's more really top-down influence. Do you have, I don't know, a forecast what role the US will play? Because, I mean, it seems very apparent that without the support of the US, this will at least be a lot less powerful instrument.
Well, it doesn't hurt that the final year for the negotiations is 2029, and that was agreed to very purposefully by some states. I have no crystal ball as to, I mean, we're all extremely aware of what Minister Keul spoke about, and others, and Judge Dickert, right? We're very aware of this, obviously, in the United States. I think there are now 151 lawsuits against the administration that have been filed. The only hope I can give you is that they're firing so many people that we don't have very heavily staffed bureaus anymore in anywhere. Our legal advisor left New York in December, Mark Siminoff, who'd been there for years, who was wonderful. There's like one person left. So they might be less effective than with no staffing, but I would agree with you that there is much more top-down control to the extent there are people able to do what has been asked of them. There are 151 lawsuits, and we'll just see where this goes. If you have advice, we're very well organized in the United States, but I don't know if we were organized for this. Yeah.
Well, Leila, obviously you are not responsible for the
I'm
US
not
administration, but I'm responsible for keeping the time, and I think we have, it gave you a hard time already with half an hour Q&A, and I think it's now the moment to finish this off. And thank you again so much, and give a warm applause to our guest speaker.